I'll be discussing the facts and findings of Avel Proprietary Limited against Mutlicoin Amusements Proprietary Limited in relation to copyright infringement. This case was significant for copyright infringement because it clarified the definition of publish pursuant to Section 29 Sub 1 and Section 31 Sub 1 of the Copyright Act 1968. And it also established that the onus rests on the party asserting infringement of copyright to prove the owner of copyright did not provide a license pursuant to Section 37 of the Copyright Act. So how did the court come to these conclusions? Let's start by outlining the facts of the case. Avel entered into a distribution agreement with Williams Electronic Games, an American company that manufactures pinball machines. The distribution agreement gave Avel the right to sell and distribute select models of Williams pinball machines in Australia. As manufacturers, Williams was the owner of the artwork displayed on the pinball machines and the computer programs which ran them. Therefore, the owner of copyright of an artistic and literary work pursuant to the Copyright Act. The respondents, Mutlicoin, were importers who were interested in importing used Williams pinball machines into Australia from separate American distributors. When Avel found out, they threatened to take legal action against Mutlicoin for infringement of copyright. In response to such threats, Mutlicoin instituted proceedings against Avel pursuant to Section 202 of the Act on the grounds that Avel's threats were unjustifiable. Avel counterclaimed under Section 202 by arguing that the distribution agreement gave them an exclusive license to Williams' copyright. And as an exclusive licensee, Avel argued that their threats were justifiable because Mutlicoin's acts would have infringed copyright pursuant to Section 37 of the Act. Therefore, the two main issues the High Court needed to consider was whether 1. Did Avel have an exclusive license? And 2. Were Avel's threats justifiable? Under Section 31 Sub 1, publish is an exclusive right to copyright. Therefore, in order to determine whether the distribution agreement gave Avel an exclusive license to Williams' copyright, the High Court needed to determine the definition of publish under Section 31 Sub 1. Avel tried to argue that publish under Section 29 Sub 1 operates as a definition for publish under Section 31 Sub 1. However, following the decision from the House of Lords in Fabrics against JTEX Shirts, the High Court held that the definition of publication under Section 31 Sub 1 means first publication. In other words, the exclusive right to publish under Section 31 Sub 1 means to make available to the public in Australia something which has not previously been made available. Therefore, Section 29 Sub 1 only sets out the circumstances of when publication has occurred, and does not operate as a definition under Section 31 Sub 1. The High Court held that Avel was not an exclusive licensee of Williams' copyright because the distribution agreement only gave Avel an exclusive right to supply, and not the exclusive right to publish. The next issue for the High Court to consider was whether Avel's threats were justified. In order to establish this, the High Court needed to consider who had the burden of proof to establish an infringement of Williams' copyright. It was unanimous that the onus rests with Avel, that is, the party alleging infringement of copyright. However, due to a lack of evidence, Avel were unable to prove that Mutlicoin would have infringed Williams' copyright. Therefore, the High Court held that Avel's threats to Mutlicoin were unjustifiable pursuant to Section 202, and Avel's counterclaim was dismissed. In conclusion, this case was important for copyright infringement for two reasons. First, it clarified the definition of publish under Section 31 Sub 1, and second, it established that the onus lays on the party alleging copyright infringement to prove the absence of a license to import copyright works into Australia.